This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an insurer is not obligated to share with a successor insurer of its insured, and why an other insurance clause only applies to concurrent policies, not to policies that come into effect after the expiration of the original policy. After the trial court granted the Travelers Indemnity Company and Travelers Indemnity of Connecticut motion for partial summary judgment, finding that indemnity costs incurred by travelers in connection with the asbestos liability of defendants' subsidiary should be allocated on a pro-rata time on the risk basis. In Travelers versus Fishbach, a decision of the New York Court of Appeal on September 26, 2023, resolved the dispute in New York Appellate Court's fashion of saying very little to say very much. The Appellate Court agreed with Travelers that it was not liable to cover costs incurred by the insured that occurred outside of the policy period, and that any cost it was entitled to cover should be allocated pro rata over the entire period during which damages occurred. The New York Appellate Court agreed with Travelers that it was not liable to cover costs incurred by the insured that occurred outside of the policy period, and that any cost it was entitled to cover should be allocated pro rata over the entire period during which damages occurred, finding that the appeal was controlled by a case called Keyspan Gas versus Munich Reinsurance, a 2018 decision of a New York Appellate Court, where the Court of Appeals found that the so-called unavailability rule, which would require insurers to bear the risk for periods when applicable insurance coverage was not available in the marketplace, was inconsistent with the contract language that provides the foundation for the pro rata approach, namely that during the policy period limitation and that to allocate risk to the insurer for years outside the policy period would be to ignore the very premise underlying pro rata allocation, let alone the only purpose of having a policy period when the policy is in effect. Thus, with respect to insurance policy language like that issued by the Travelers, which limited indemnification to losses and occurrences during the policy period, the insured and not the insurer bore the risk for those years during which such coverage was unavailable. Defendants' contention that the Supreme Court, the trial court in New York, erred by failing to give effect to the other insurance provisions in the Travelers' policy was unavailing. New York law is clear that other insurance clauses do not apply to successive insurance policies. Thus, despite the fact that the subject provision contains no temporal or policy period limitation when harmonized with the definition of bodily injury, the other insurance provisions within the Travelers' policies pertains to concurrent policies that name defendants or their subsidiaries as additional insureds. Defendants provided no evidence that the 1990 settlement with Travelers had anything to do with litigation commenced 4 years later. The Supreme Court therefore correctly determined that as the release explicitly limits itself to current and future obligations and liabilities for premiums, it was irrelevant to the allocation of indemnity costs. In my opinion, New York ignored spurious claims and applied the clear and unambiguous language of the Travelers' policies to find that there can be no coverage applied as a result of the other insurance clause to other insurance in effect after the termination of the Travelers' policies. Sharing only occurs when policies in effect at the same time for the same loss Both have other insurance clauses that require pro-rata sharing of losses, not sharing 4 years after settlement for a different claim after expiration of the traveler's policies. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detailed information about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my Substack publications or my locals community. Thank you for your attention.